Greetings! Welcome to episode 2 of our 9-episode look at the courts and trials process. Today we're going to look at the court process as a whole. We're going to look at the process that a single case will follow throughout its journey. So to begin, let's assume that Joe is accused of killing Mary. What's going to happen? Well, this case is going to pass at least 2 and up to 5 different courts throughout its journey through the court system. The first is what we are going to call a court of limited jurisdiction. These courts handle preliminary matters. They are limited in what they can hear, and that is simply the definition of jurisdiction. Jurisdiction is the power of a court to hear a certain case. Courts of limited jurisdiction receive their authority from courts of general jurisdiction. And courts of limited jurisdiction will deal with preliminary matters. So when Joe is charged, the prosecutor is going to file the charges with the court. Joe, within the first 24 or 48 hours after being charged, is going to show up in a court of limited jurisdiction. Those courts go by lots of different names. Depending on what state you're in, the name may be different. It may be an associate circuit court. It may be a district court. It may be a district justice. Different places have different names for them. Once this case has gone through its preliminary steps, the case then will move to a court of general jurisdiction. This basically means that the court can hear all types of cases. It doesn't matter what the case is, the court has authority to hear it. Courts of general jurisdiction are also courts of original jurisdiction, meaning this is where the case begins and where it starts. These also have lots of different names associated with them. It may be a circuit court, it may be a district court, it may be a superior court, it may be a court of common pleas. If you're in New York, it's actually called the Supreme Court. And so we're not going to focus on the label as much as we're simply going to call these trial courts. This is where the case, if it goes to trial, will actually be heard. Also, this is where 90 to 95% of all criminal cases end. So those are the 2 courts. The court that Joe will face would be the court of limited jurisdiction and the court of general jurisdiction. In a very small percentage of cases, however, the defendant goes to trial, the defendant is found guilty at trial, and then the defendant wants to appeal. When the defendant appeals, it will go on to an intermediate Court of Appeals. This is a very different system, a very different process than the trial system, and we'll discuss that in episode 9. Once the court goes through once the case gets through the intermediate court, then it will go on possibly to the state Supreme Court if it's a state criminal case. The state Supreme Court does not have to take the case. Generally, it will have different rules that will allow it to determine which cases it takes and which cases it does not. Finally, in the most extreme circumstances, if it's a state criminal case, the U.S. Supreme Court might get involved if there is a violation of the U.S. Constitution at somewhere along those lines. It is very rare for the U.S. Supreme Court to take a criminal case from a state court. And that brings up the second key piece of this. If Joe kills Mary, that is going to be a state charge. It's a state crime. The federal government will not get involved in it. However, if Joe has defrauded Mary and a whole bunch of other people and has obtained millions of dollars through that fraud, then that is something the federal government may choose to prosecute, in which case it will go through a very similar process. The only difference is it will not have a state Supreme Court. It would go straight from the Intermediate Court of Appeals to the U.S. Supreme Court. Okay, so that is our basic court structure. Now we need to look at the process. What's going to happen in this case? Well, we need to think about our facts, right? So we know that Mary is dead. The police are going to investigate, and during the course of their investigation, let's assume they have identified Joe as the offender. They are going to go to the prosecutor and ask the prosecutor to file criminal charges. It will be up to the prosecutor to decide when to file charges, what charges to file, and against whom. So depending on the facts, the prosecutor may charge Joe with murder first degree, murder second degree, voluntary manslaughter, or involuntary manslaughter. All of those are potential charges when one person kills another. Once the prosecutor has made that decision that we're going to file charges, and for the sake of argument we'll say they're murder first charges, the prosecutor must at least have probable cause. Once we have that probable cause, the prosecutor will take the case to the court. His first appearance is going to occur within about 24 hours of arrest. At that time, the judge is going to tell Joe that Joe has been charged with murder in the first degree and the death of Mary, and that is called an arraignment. It's the formal reading of charges to the defendant, so the defendant knows what it is the defendant has been charged with. Immediately following this arraignment, the judge is going to ask if the defendant needs an attorney. Basically, that means, do we have a public defender who's going to represent you, or will you go get a private attorney? Until that happens, there will not be any further steps in the process. A judge cannot go through any critical stage in the process without having the defendant with counsel, especially in a case as serious as a murder charge. Once counsel has been obtained, and usually in these circumstances a public defender will just stand in to make sure the proper process is followed, the judge will turn to the conditions of bond. Bond is whether or not the defendant should be released pending the outcome of the case. The judge looks at two different things. The first is the seriousness of the offense. Is this person likely to go out and commit another crime while they are on bond? Is there a risk of harm to the community? And in a murder case, that's going to be presumed that the defendant, if released, would be a threat to society, and therefore that alone is going to make the bond rather significant. The second thing the court will look at is whether or not the defendant will return for future court dates. Again, a murder first charge, as we're using for our example, is indicative that there's a good risk of flight. The defendant, if convicted of murder, could be looking at a life sentence at minimum, potential death penalty involvement, and so as a result, the risk of flight is very high. So as a result, the outcome is going to be the judge will set a rather high bond for the defendant to make, and most likely the defendant would not make that bond. We can imagine a drug case for a first-time drug offender. The person is not a risk of violence in the community. The person is likely to reappear in court. Therefore, our bond is going to be set much lower. In fact, we may not require any money up front that the defendant must post. So once we've done that first set of things in the court of limited jurisdiction, the next step is there must be a probable cause determination. A neutral body, apart from the prosecutor, must decide that yes, there is probable cause to believe this crime has occurred, that Joe committed the crime, and therefore it should go on to the trial stage. There are two different ways that we can determine probable cause at the pretrial stage. The first is a preliminary hearing. This is essentially a miniature trial. So Joe will be there, Joe will have his attorney there, the prosecution will also be in court and present witnesses to establish probable cause that Joe killed Mary. The rules of evidence are going to be applied, and the judge will be there to make sure that those rules are enforced. The prosecutor will ask questions first of the witnesses. The defense attorney will have the opportunity to cross-examine. At the end of this short hearing, the judge will determine whether or not probable cause has been established, and in just about every case it is. At that point, the prosecutor will file what is called an information. This is the formal charging document that indicates that Joe is charged in the murder of Mary. Alternatively, the prosecutor could skip the preliminary hearing and instead take the case to a grand jury. A grand jury is a group of people ranging from 5 up to 24 who do nothing but sit and listen to cases and determine if there is probable cause to believe the defendant committed the crime for which the defendant is charged. In this particular instance, Joe would not be present for the grand jury. Joe's attorney would not be present. No judge would be present. In fact, the only people there in the grand jury would be a court reporter, the prosecutor, and the witness. The prosecutor would ask questions of the witness would answer the questions. Joe, his attorney, would not be able to be there or even know that this is going on. After probable cause has been determined, the grand jury is going to return what is called an indictment. This is, like the information, a formal charging document, and basically is going to say the same thing. The two are almost indistinguishable except for the label that is placed on them. Once the indictment has been filed, then the court is going to move the case from the limited jurisdiction to the court of general jurisdiction. Once it moves to the court of general jurisdiction, it's going to begin addressing pretrial matters. The most important pretrial matter is going to be discovery. The prosecutor is required to give certain information to Joe's attorney and therefore to Joe about the case. The U.S. Supreme Court, in 2 different opinions, has said that prosecutors must turn over exculpatory information to the defense, and they must turn over any impeachable information to the defense. What are these things? The first is exculpatory information. Exculpatory information is any information that would indicate the defendant did not commit this crime. So anything that makes Joe look innocent, that must be turned over to the defense. Impeachable information is any information that would make the witnesses against Joe not credible. This could be prior convictions, it could be prior inconsistent statements, it could be a bad reputation for honesty, any number of things. Once again, the prosecution must turn exculpatory and impeaching information to the defense. After that, the court must also deal with court discovery by court rules. So in addition to those 2 things, most state courts require that prosecutors and defense share information about the case. Prosecutors must turn over all the police reports, they must turn over witness statements, they must turn over any lab reports. If there are statements made by the defendant, all of those things must be supplied to the defense. Similarly, the defense, if they conduct any investigation that produce reports, if they get any independent lab results, if they're going to rely on alibi witnesses or an insanity defense, then that information must also be supplied to the prosecution. Beyond discovery, there are several pretrial motions that may arise. The first is what we'll call procedural motions. These are things like motions to change where the trial is going to occur, what we call change of venue. It may be a change of judge. It may be to separate multiple defendants. It may be to separate multiple counts. Joe might have several different murders that he is accused of committing, and therefore he might want to try each of those things separately. That would be what we call a motion for severance. There are also evidentiary motions that a defendant could file. These are what we would think of as motions to suppress evidence, motions to suppress identification, motions to suppress statements. Finally, at these pretrial stage, we are going to have plea negotiations. The prosecution and defense are going to talk about what potential outcomes might arise with this case. And this is where 90% of our criminal cases are going to end. Eventually, the prosecution and defense are going to come to an agreement. The defendant is going to go before court and admit guilt to the crimes that the prosecution and defense could agree upon. However, not every case ends that way. There are still roughly 5% of all criminal cases that go on to trial. And in trial, the defendant has the right to a jury trial, but could decide instead to take a bench trial. A bench trial is simply one where the judge decides whether the person is guilty or innocent or not. So let's assume that Joe decides he wants a jury trial. A jury is going to be impaneled. They're going to call a group of citizens to come and basically go through what we call a voir dire process to tell the truth. The prosecutor and the defense will have the opportunity to question the prospective jurors. In some jurisdictions, the judge will do that as well, or will do that instead of the prosecutor or the defense attorney. Once we're through the jury selection process, we will have opening statements. The prosecution must give an opening statement. It is the prosecution's burden of proof, and therefore the prosecution must provide the evidence first. Following the prosecution's opening statement, the defense can give an opening statement if they so choose. They can decide to give the opening statement immediately. They can wait until after the prosecution's case in chief, or they can decide not to give an opening statement at all. After opening statements, the prosecution must put on what we call its case in chief. This is where they begin calling witnesses. So if Joe killed Mary, most likely the first witness is going to be the medical examiner. The medical examiner is going to come in and talk about how Mary died. Or it may be a family member to come in and talk about, how they know that Mary is no longer living. The prosecution will ask questions first. When the prosecution is done asking questions, the defense attorney will have the opportunity to stand up and ask questions of the witness. Those questions will take a different form. They will be a lot more challenging than what the prosecution's questions were. The prosecution would ask open-ended questions. The defense attorney is going to ask close-ended cross-examination questions. When the defense is done, the prosecution then can call its next witness, and this will continue on and on until the prosecution has presented all of its witnesses. Once that has happened, the defense now has an option. If the defense hasn't made an opening statement, it can do so. If the defense would like to present evidence, it may do so. Or if the defense doesn't want to do anything, it can simply say, Your Honor, we have no evidence, we are not going to present a case. This is all because of the presumption of innocence and burden of proof. It is the prosecutor's job to prove beyond a reasonable doubt each and every element of the offense charged. The defendant doesn't have to prove innocence. This is a very important concept in our system. And that's why the defendant doesn't have to give an opening statement, doesn't have to provide any evidence whatsoever. Finally, if the defense does present its case in chief, then it will work the same way as the prosecution's case in chief. The defense will present its witness, the prosecutor will have the opportunity to cross-examine. Once all the defense witnesses are done, then the case will move to its final stages. First, the judge will instruct the jury. This is the instructions for what the jury should do with the case, how they are to consider the evidence, what it is the prosecutor must prove beyond a reasonable doubt. Once these instructions have been provided, then both sides will give a closing argument. The prosecution will go first, the defense will go second. Both will have equal amount of time. In some jurisdictions, the prosecution gets to go after the defense. Once the closing arguments are done, then the jury will deliberate and reach its outcome. The judge will accept the verdict of the case, which can be either guilty or not guilty, and that will bring an end to the formal court process.